The pistol brace rule is dead, struck down, vacated nationwide. That fight is over, and the good guys won. Except something very strange is happening behind the scenes that most people haven't caught yet, because while one arm of the federal government is telling a court that nothing actually changed and that prosecutions can still happen, another arm of the same government just released a budget document that says the exact opposite. These two positions cannot coexist, and the tension between them reveals something critical about the real state of pistol brace legality in this country. What the government is doing with one hand versus the other should concern every single firearms owner, because this is not just about braces anymore. This is about whether a legal theory can survive the death of the rule that was built on top of it. And what just came out of the White House budget adds an entirely new dimension to this story that changes the calculus for everyone paying attention. Let's rewind and establish the full picture so that everything that follows makes complete sense. The previous administration pushed through a rule that attempted to reclassify the vast majority of pistol brace-equipped firearms as short-barreled rifles under the National Firearms Act. That rule, if enforced, would have turned millions of law-abiding gun owners into felons overnight unless they registered their firearms, destroyed them, or turned them in. It was one of the most aggressive regulatory moves against firearms owners in recent memory, and the backlash was immediate and overwhelming. Lawsuits were filed from every direction. Gun owners, advocacy groups, and multiple states challenged the rule on constitutional and administrative law grounds. The critical breakthrough came when a federal judge struck the rule down entirely and issued a nationwide vacatur. That meant the rule wasn't just paused or blocked for specific plaintiffs. It was erased from the books for everyone. When the new administration took office, they made the decision to drop the appeal that had been filed by the previous administration's legal team. That concession effectively sealed the deal. The pistol brace rule was officially dead, and there was no path to revive it through that particular legal avenue. After that happened, most of the remaining lawsuits challenging the brace rule were dismissed. The courts and the parties involved agreed that there was nothing left to fight over. The rule was gone, the cases were moot, and everyone moved on, or at least that's what appeared to happen on the surface. Here's where things get complicated and where the real story begins. There is one major case that has not been dismissed, and it's the challenge brought by a coalition that includes a prominent gun rights organization and the state of Texas. This case is still very much alive, and the reason it's still alive is because the plaintiffs in this case are asking for something fundamentally different from what every other lawsuit was seeking. They are not just asking the court to acknowledge that the brace rule is gone. They already know that. What they want is a permanent injunction, a binding court order that prevents the federal government from enforcing the underlying legal theory that pistol brace firearms can be classified as short-barreled rifles under the existing statutory framework. This distinction is absolutely crucial, and it's the key to understanding everything happening in this fight. The federal government's position in this remaining case is remarkably revealing. In their court filing arguing that this case should be dismissed, the government made a statement that should make every firearms owner sit up and pay attention. They stated plainly that even though the pistol brace rule has been vacated, they are still enforcing the National Firearms Act and the Gun Control Act against certain brace-equipped pistols. They went further and explained their reasoning, arguing that this should surprise no one because the vacatur of the rule never changed anyone's underlying statutory obligations. In other words, the government is saying that the rule was just a formality, a clarification of authority they believe they already possessed. Kill the rule, and the authority remains. The legal theory that certain pistol brace configurations constitute short-barreled rifles doesn't depend on the rule at all, according to this argument. It depends on the statute itself. Think about what that means in practical terms. The government is essentially saying that they never needed the rule in the first place. The rule was just their way of putting everyone on notice about how they interpreted the existing law. Now that the rule is gone, the interpretation hasn't changed. The enforcement posture hasn't changed. The legal risk for gun owners hasn't changed. Everything is exactly the same as it was before, minus the formal regulatory document. That is a staggering position for the government to take publicly in a court filing, and it explains precisely why this remaining legal challenge is so important. Now layer on top of that what just came out of the White House, and you start to see the contradiction that sits at the heart of this entire situation. The administration released its new budget proposal for the federal law enforcement apparatus, and buried within that document is language that directly addresses firearms regulations, including pistol braces. The budget explicitly discusses moving away from prior firearms regulations that effectively criminalized law-abiding gun ownership. It specifically references pistol brace restrictions, regulations targeting homemade firearms, and other regulatory enforcement actions tied to federal firearms enforcement agencies. The language in the budget goes even further, stating that prior policies subjected gun owners to serious criminal penalties over items like pistol braces, and the administration is now signaling a deliberate policy shift away from those types of enforcement approaches. So now you have two completely different messages coming from two branches of the same government at the same time. On one side, the legal team is standing in front of a federal judge and saying that nothing has changed, that the authority to prosecute brace pistol owners as possessors of unregistered short-barreled rifles is fully intact, and that the death of the rule is essentially irrelevant to their enforcement power. On the other side, the policy team sitting in the White House is drafting budget language that says the government is moving away from exactly those types of enforcement actions, and that the previous approach was an overreach that unfairly criminalized ordinary gun owners. These two positions are in direct tension with each other, and the gap between them reveals something important about the difference between legal authority and political will. This is the part that requires careful attention because it affects every person who owns a brace-equipped firearm. The government's legal argument is that the statute provides the authority. That authority exists regardless of which administration is in power, regardless of what any rule says, and regardless of what any budget document promises. A policy shift is not a legal change. An administration can promise all day long that it won't pursue certain cases, but that promise evaporates the moment a new administration takes office with different priorities. Legal authority, on the other hand, stays in place permanently until a court strikes it down or Congress changes the law. Policy is a mood, legal authority is infrastructure, and the infrastructure the government is describing here would allow any future administration to walk right back into this space and start prosecuting brace pistol owners without passing a single new regulation. This dynamic is exactly why the remaining legal challenge is the most consequential piece of the entire pistol brace saga. The plaintiffs in this case understand that policy promises are not worth the paper they're printed on when it comes to long-term protection. They are not asking for a promise. They are asking for a court order. They want a federal judge to rule that the government's interpretation of the statute is wrong, that brace-equipped pistols are not short-barreled rifles under the law, and that no administration, current or future, can enforce that theory against gun owners. A permanent injunction of that nature would create a binding legal precedent that would survive changes in administration, changes in enforcement priorities, and changes in the political winds. Without it, the current detente is nothing more than a gentleman's agreement that can be broken at any time. There's also another significant development happening simultaneously that adds even more complexity to the landscape. The recent departure of the Attorney General creates a period of transition within the leadership of the federal law enforcement apparatus. An interim replacement is currently serving, but it remains to be seen who will ultimately fill that role permanently and what their enforcement philosophy will be. Personnel changes at the top of these agencies can dramatically alter the direction of enforcement, and what seems like a settled policy today can look very different 6 months from now under different leadership. On a more encouraging note, the budget does allocate significant resources to Civil Rights Division efforts related to Second Amendment issues. That signals at least some institutional commitment to treating firearms rights as genuine constitutional rights deserving of federal protection and advocacy. The Civil Rights Division has done noteworthy work on Second Amendment matters in recent months, and increased funding could accelerate those efforts. But here again, funding allocations and institutional priorities are subject to the same political winds that govern everything else. What gets funded today can get defunded tomorrow, and the direction of civil rights enforcement depends heavily on who is giving the orders. So, where does all of this leave the average firearms owner who has a brace-equipped pistol sitting in their safe? The honest answer is in a state of legal uncertainty that is more nuanced than most people realize. The formal rule is gone, and that is a genuine victory that should not be minimized. Nobody is going to be prosecuted under the specific regulatory framework that the previous administration created, but the government has plainly stated in court filings that it believes the underlying authority to classify brace pistols as short-barreled rifles still exists within the text of the statute itself. The White House budget signals a political unwillingness to exercise that authority aggressively, but political unwillingness is not legal inability. The only thing that can truly resolve this tension is a court ruling that addresses the statutory interpretation question directly, and that is exactly what the remaining legal challenge is designed to produce. The next several months will be critical. The court's handling of this case will determine whether the government's preserved legal theory survives or gets dismantled. If the plaintiffs succeed in obtaining a permanent injunction, it would represent the most comprehensive legal victory for pistol brace owners since this entire fight began. It would mean that not only is the rule gone, but the legal foundation that the rule was built upon is gone too. No future administration could simply dust off the old playbook and start again. If the case gets dismissed, however, the legal theory lives on as a loaded weapon sitting in a drawer, waiting for someone to pick it up and use it. The broader lesson here extends well beyond pistol braces. This situation perfectly illustrates how the federal government maintains legal authority even when it publicly signals restraint. Regulatory actions can be struck down, rules can be vacated, administrations can change, and budget documents can promise reform. But unless the underlying legal interpretation is challenged and defeated in court, the government retains the ability to reverse course at any point. That's why judicial victories matter more than executive promises, and it's why the firearms community should be watching this remaining case with intense focus, regardless of how favorable the current political environment might appear. The pistol brace rule is dead. The legal theory behind it is very much alive. The White House says it wants to move in a different direction. The lawyers in court say nothing has changed, and one case remains standing that could resolve this contradiction once and for all. How it plays out will define the future of pistol brace legality in this country for years, possibly decades to come. That's it for today, folks. See you in the next video.